We thank you so much for staying on Law School Made Easy, and thank you for watching Law School Made Easy at Law School Made Easy 256. Thank you for sharing our videos and liking them. Thank you for the comments, and we urge you to continue subscribing. If you've not subscribed, please hit that button below the video and subscribe and like. Also turn on the notification button for more and more of these videos. My name is Walter, and today we want to go straight into the defense of insanity. Important to note when discussing the defense of insanity, is that we must bring to the attention of the examiner section 10 of the penal code of this country, Uganda, that everybody is presumed to be of sound mind until that time which comes into question, and we begin to doubt whether this person is of sound mind. But everybody you see walking, the assumption is that that person is of sound mind. And after that, then we can straight enter into section 11 that clearly defines what we mean by insanity. Section 11 suggests that somebody, remember we said that we must prove when the defenses can stand and when they can fail. When the defense can stand and when the defense can fail. So you only raise a defense of insanity if it is really true that you are insane, and then you prove that, yes, me, I am a mad person. I do not understand. I didn't know what I was doing. So that is the only way you can prove the defense of insanity. So let's enter into section 11 that clearly suggests and says that somebody is criminally, will not be criminally responsible for offense committed if this person is affected by the disease of the mind. You are affected by the disease of the mind, and at the time of commissioning the offense, you could not know or differentiate or distinguish between what is good and what is bad. If you are in that state, then the law is very clear: you will not be criminally responsible. But somebody can be criminally responsible even when is affected by the disease of the mind. But they are able, at the time of commissioning the offense, they are able to know that what I'm about to do is bad. Then that way you can be criminally responsible. So those are the ingredients. Those are the things you must prove. Number one, you must prove that this person was affected by the disease of the mind. That the disease of the mind affected them to the extent they could not differentiate between good and bad. And again, somebody can be criminally responsible for an offense committed if they are affected by the disease of the mind, but at that time which comes into question, they know that what they are about to do is bad. Then that way, that person is criminally responsible. Let's look at the leading case there, McNaughton's case. In this case, McNaughton he killed somebody called Drummond, mistaking him for the prime minister. And he was killing them because of his worries that politicians had taken away the life they had, that they were suffering because of these politicians, and he killed somebody instead of the other. And for him it was okay, because when arrested he was lamenting, these people have taken away their property, we are poor because of them. And this case reached in court, and the House of Lord instructed, because there's a school of thought that this was the first case about insanity, and the House of Lord had to sit to distinguish, to set the elements I've just talked about up, to set the elements, the ingredients of this defense, that when could this defense stand on bringing many people or evidence, witnesses. They all affirmed that Mark Newton was suffering from, was insane from all his behaviors in the past. However, the House of Lords resolved and gave us the guiding principles that we must look at while discussing the defense of insanity. And whatever you see in section 11 is the resolution, is the holding made in Mark Newton's case. And they said that somebody shall be criminally responsible if those people are affected by the disease of the mind. And the disease of the mind affects them to the extent that they cannot know or differentiate between good and bad. And further, that somebody can be criminally responsible even if they are affected by the disease of the mind, but at that time that comes in question, while committing the offense, they are able to differentiate, to know what is good and what is bad. So that is the only way that defense can stand, that you will be responsible. So the challenge now for us as students comes here, to distinguish between diminishing responsibility and insanity. But in our subsequent video, we shall discuss in depth the diminishing responsibility. But diminishing responsibility is the abnormality of the mind. It is kind of permanent, but again here, you are affected by the disease of the mind, incapacitating you to know what is good and bad. But of course, in our subsequent video, we shall discuss the diminishing responsibility in depth. So that is the defense of insanity. So we thank you so much for staying on Law School Made Easy at Law School Made Easy 256. I will urge you to subscribe, to share, and like our videos. Subscribe, share, and like our videos. Thank you so much.